Welcome to the viewers and learners. Today we are going to discuss one of the important subjects related to the case laws, that is the case laws related to the services covered in the Consumer Protection Act. You know, as I said several times in my earliest videos, Consumer Protection Act covers two aspects. One is the goods bought or sold or services offered or hired. Now, in this today's discussion, we will concentrate some important cases on various types of services covered under this act concerned. Now, before we deal with the case laws, let me also very briefly list out what are the services are covered under this. The services include housing, which includes house construction, house leasing, house purchase, house sale, everything, house related things. The next one is the banking. Banking services relates to banking, opening of the account, maintenance of the deposit, borrowal of the loans, keeping of the jewelry in the banks, and several aspects are concerned. Those services are covered under the banking and services concerned. And the third major one is the insurance. We are insurance, all life insurance, general insurance, all life insurance are covered. Life insurance is very, very important. Then thereafter, medical services is covered, but we will not discuss because there is exclusive discussion on the medical service concern. So we will not take the medical service concern. Then courier services, postal services, very, very important because for communication, transmission of the documents, important documents. So courier services are also covered under this. Then transportation, all type of road transport, rail transport, air transport, by air travel, all these things are covered under the services. And also supply of electricity, very important for our for all of us. Then there are certain deficiency in services or cases have come before the courts also. And also telephone services. We have come across telephone is essential communication system we are having it, and including the legal profession. So these are some of the various services covered under this, but we will try to see some of the case laws on at least one case law on each of the services I just referred above. Now let me straight away come to the services and the house construction, housing related services. See, house is very, very important. Roti kapda makan. Everybody's dream is to have a house owned by himself or herself. It's a lifelong dream. Then very often we individuals we do not have that bulk amount in our hand to construct a house by ourselves. So we have to go for a loan, or we have to again the lands are available freely. So it's very often in the cities and metropolitan places, the builders they acquire the plots and they construct the house, then they sell it to the people like us only. So therefore, the third man is involved in the sale of the house construction and all. Then the quality of the material used is very, very important because we often come across bridges collapses, houses collapses, even within a year of construction and all. Poor quality of material used, these are the main reason for this sudden damage of this house construction and all. So therefore, these are the aspects, various aspects covered under the house construction is concerned. Let me tell you one by one. House construction, the major cases came before the court are very often it's millions of people are facing. The builder, they make a promise that the possession of the house fully constructed, ready for moving, will be given within a period of time, like say 3 years or 4 years. But in 90% of the cases, they do not hand over the possession despite collecting the full amount. From the person like common man is concerned. So this is one of it's a common thing taking place, and this type of delay cost in the delivery of the person is one of the main deficiencies in service related to the housing is concerned. Then what other things are? As I said, the poor quality of material used. This can be seen, because at the time of advertisement, they give all the specifications, what type of material will be used. If the material used is not in conformity with the the specification provided in the advertisements or the booklet, then definitely that will give a scope for a deficiency in service. Then of course sometimes there may be differences between the area of square feet promised and actual, and the difference in the area assured and the actual area of possession handed over and all. So these are some of the common issue. Poor quality of material used is very important deficient service in the housing is concerned. Now with this brief introduction, let me take a very specific case, important famous case decided by the Supreme Court of India, where that is on the housing is concerned. That is the Lucknow Development Authority versus M.K. Gupta. It was reported in the year 1994 but even today this case is being quoted, referred very extensively whenever any housing related deficient service case comes before the court. Now let us see what has happened in this case. Lucknow Development Authority was not handing over the possession of the flat even after payment of the entire amount by the person who just demanded for a house from the Lucknow Development is concerned. Then the person who paid the full money and who could not get that possession despite waiting for a long time, he filed a case before the district forum, Lucknow district forum, and the district forum, after hearing the case, directed the Lucknow Development Authority to pay interest on the deposit amount handed over to the builder along with interest, and also the refund of the entire amount. Since the builder failed to hand over the possession, the builder was directed to pay the entire amount along with the interest at the rate of 16%. Then thereafter the matter was referred to the builder went on appeal to the National Commission. The National Commission, after examining the case, came to the conclusion that there is really a deficiency in service. So in addition to upholding the decision given by the district forum, which directed the builder to repay the deposit amount along with interest rate, in addition to this direction, the National Commission awarded a further rupees 10,000 as a compensation for causing the mental agony and torture is concerned. Again, the builder went on before the Supreme Court, and the Supreme Court, the issue raised by the Supreme Court was whether statutory bodies like Lucknow Development Authority is covered under the jurisdiction of the Consumer Protection Act is concerned. That's the main issue. Whether the statutory authorities are covered under the Consumer Protection Act or not. That's the only major issue. Then, but after examining the matter again, the Supreme Court gone into all the details and found that, and came to this, they made this observation, that is, when the statutory authorities like development authorities use a substandard material in construction or makes misleading representation about the condition of the house, it is the denial of the facility or benefit to the consumer, and also leads to harassment, and therefore it's a clear case of deficiency. Again, the Supreme Court awarded a compensation of rupees 10,000 to be this is why this case is very important. As I said, in this case the Supreme Court directed that the compensation of rupees 10,000 should not be paid by the statutory authority from its own resources. Instead, this 10,000 rupees should be recovered from the concerned delinquent officer who were responsible for delaying this possession and all. In addition to that, 5,000 cost was awarded. So this is one of the famous case on the house construction is concerned. As I said, there are several other issues, but we'll now move on to other services. Now, what is the next important service that will be discussed? Insurance services. See, insurance, again, there are different types of life insurances, that life insurance, corporate, then other than insurance of the materials. Even the house, we can go for car insurance. There are all the insurance available for all the goods we procure or we store, or all the things are in the way, all the vehicles, all these things insurance covered. Now, what are the common insurance related deficiency in services? Very often, whenever we go for taking insurance policy, the insurance agent comes with several promises, assurances. They say, taking all from that, said that whenever the claim will be settled easily, then whenever with regard to medical insurance concerned, that the company will meet all the medical charges whenever the patient, this insurance the policyholder say fall sick and is admitted in the hospital. Likewise, then there are no any hassles and all. This type of all tall promises are made. But whenever in reality, even some cases have come before the court of law, this insurance company failed to even return the amount within time after the maturity period is concerned. And also the medical insurance policyholder facing a lot of harassment. Contrary to the promises made, the insurance authorities, they not even pay 15 to 20% total expense incurred by the medical policy holders. And also these are the serious issues related to the insurance concern, and insurance services covered under the Consumer Protection Act. Now let us take the one case of this nature. Is what is that case that very relevant for our discussion is. This is Ursula Motor versus National Insurance Company 2005 case. It's about the case dismissed by the National Commission. Now what has happened in this case? A company took an insurance policy for to cover risks associated with their commercial units. This is about the case about the. Now the issue is, as I said in my several videos, that all goods or goods purchased for commercial purpose is not covered under the definition of the goods or the commercial also. So anything purchased for commercial purpose is outside the purview of the Consumer Protection Act. Now that is what this point was made elaborated by the National Commission in this case, whether a company, not an individual, which took an insurance policy that to cover the risk associated with their commercial units. Commercial units, the commercial connotation comes into play. But that's what. Then there was some dispute arose between the insurance company. Actually, the insurance holder claimed for the damage caused to the products in the commercial units. But the company refused to honor that claim on the ground that this unit is policy is taken for the commercial purpose. Therefore, the policy cannot be honored. Then the State Commission, again matter went to the State Commission, accepting the pleas raised by this insurance company. State Commission dismissed the complaint on the ground that insurance was taken for a commercial purpose, which actually is not the case. That's what the National Commission clarified it. But then again on appeal, the policyholder went on appeal to the National Commission. The National Commission observed that if the goods are purchased for commercial purpose, then such consumer would be excluded from the purview of the Consumer Protection Act. That is okay. But however, most important, this is what the findings of the National Commission. If the same manufacturer purchases a refrigerator or a TV or AC for use either at the office or residence, it cannot be held to be for a commercial purpose. This is the distinction. It may be a commercial unit, but the commercial unit, if the purchases AC for its own employees' use or even refrigerator for their own recreation rooms and all, such type of purchases will not be termed as the commercial purpose. Therefore, finally, insurance, then it also further clarified, insurance policies only for indemnification and actual loss cost. It is therefore, it is not intended for generating profit. This is what the addition made by the National Commission. So, insurance is taken not with the intention to earn profit in the case of commercial purpose. Commercial purpose means it's for the profit connotation is there very much. But in the case of insurance policy, it's only for the indemnification and the actual loss incurred. Therefore, insurance policy even taken by the company and involved or engaged in a commercial business, then such of insurance will be very well covered under the Consumer Protection Act is concerned. This is the addition made by this National Commission with respect to this insurance concerned. Now, courier service, very, very important. There was, I remember one Rocky is around the corner. Rocky, we all know it, what is the objective and all. A person residing in India, they sent a Rocky to person residing in America by post only, courier service only. The intention of we know the Rocky is Rocky as the date of the Rocky festival is very, very important and significant. So the courier, the family members, they went to the courier office, made an inquiry. How many days it will take for sending a courier by post, courier from India to America. They said that it will take 4 to 5 days. Then by calculating that 4 days before the Rocky day, they sent that Rocky in a sealed cover and they sent it by courier. With the purpose was that the Rocky should be received with the person at the America on the date of the Rocky only. But unfortunately, the courier, due to delay in the courier service of the concerned company is concerned, the Rocky was handed over after the Rocky festival was over. Then these people got offended, then they filed a case before the consumer court, so alleging that there was a deficit in the service. Then this courier company objected. It's a normal delay during the course of the service of the company, so the company is not liable for it and all. But the National Commission did not agree to such a argument placed by the courier company. They said no, it is having emotional attachment, religious connotation is there, faith is there. So when they wanted to send Rocky should be reached in that particular plane, they should have taken adequate care and caution. Accordingly, the insurance company was held liable for delay caused in the handing over making delivery of the Rocky is concerned. Accordingly, compensation was awarded to the family members. Likewise, there are several other cases are also, but another interest casing, I would like to take it on this courier service concern. In this case, this is the Osiri Devendra Panikar versus Day-to-Day Courier Service, the another courier service. In this case, the complainant, that is the consumer, sent a consignment containing important papers through courier, but the document were not delivered to the consignee. Again, the same delivery was not consignee. And but at the same time, then case was filed before that courier company. Courier company took the plea that liability of that this transaction was limited to the extent of only 100 rupees. Therefore, the company cannot be held liable for non-delivery of the document is concerned. Then the district forum, by seeing that this disclaimer clause limited held that there was a deficiency in service on the part of the insurance company. However, the liability was limited to the extent of rupees 100 only, equivalent to the liability restricted by a disclaimer clause printed at the back of the bill. Now again, the appeal gone on appeal before the higher court, National Commission. Then the issue before the National Commission was, can an unilateral liability disclaimer or liability limitation restrict the liability of the service provider in the case of deficient service, in the case of courier company? So just because it's very common sense. If you send a document worth thousands of rupees or lakhs of rupees, can that liability be, even maybe a check also? Of course, now we have the online transactions and all. Suppose if you check your worth a lakh of rupees by courier to the person at far places. Now, you buy the insurance, this courier company says that we will limit our liability class only to the 100. Is it fair? Definitely it's not a fair. So, in this case, that is what the issue involved this case, this amount too. And therefore, the National Commission concluded that liability limiting clause was not applicable as provision related to the same were in a small print. In this case, in any case, such liability limiting clause is not applicable. But in this case, the additional ground for notice was the printing of that liability limiting clause was so small, which could not be read by any person with average eyesight and all. So therefore, on this ground, it conclude there was a deficiency in service because the printed matter was in a small print and had been brought to the notice of the complainant, which was not readable at all. Accordingly, a compensation of rupees 10,000 was awarded in favor of the consumer concerned. So that's what the deficient services proved in this case also. Now we will move on to another banking service, very important. As I said, no, there may be several cases have come to the knowledge of before the court and all. Very common thing, the people, they keep the deposit in fixed deposits, which assures them a certain assured interest rate at the time of maturity and all. Very often the banks fail to honor the fixed deposit on the date of maturity, meaning thereby they refuse to say pay the maturity value on the date of maturity for various reasons. Some of the reasons were also because of the bank employees used to commit say fraudulent acts, and they swindle the money of the poor consumers, and this type of case also come to the court. But as per the deficiency in service in banking service concerned, these points are very, very important. Failure to return the fixed deposit after maturity, then definitely it will be a deficiency in service. Then what type of things are? Very often we keep valuable properties in the bank lockers, jewels, even currencies, documents, our insurance policy or even the national savings certificates, we keep in the documents also, or even the bank, our property documents all. If this documents, jewels are lost when it was in the kept in the custody of the bank lockers, inside the bank locker, can the bank be held liable? Yes, bank can be held liable for loss of property or values kept in the bank locker is concerned. And the loan related matters, poor man, common man, and very often the loan sanctioned, there is inordinate delay cost in the loan sanction is concerned. Then once the loan is sanctioned, then inordinate delay cost in the disbursement of the loan. Like loan sanction is one thing, that due to cost in the escalation, if the delayed the installment is released, the borrower has to meet the overburden of the cost and all likewise. So these are some of the say prominent say banking related services which are covered under Consumer Protection Act is concerned. Now let us take a specific case, very important case is concerned. Pradeep Kumar Jain versus Citibank case. This is about the facts about a person, consumer bought a car on hire purchase from Citibank. Then he issued 2 checks in favor of the insurance company for the purpose of taking insurance for the company, for two checks towards insurance premium for 2 years, and delivered the same to the bank. So he took the bank loan, and while taking the bank loan, he handed out 2 checks meant for insurance premium to be handed over to the insurance company, but the check was physically handed over to the bank. The bank, for one reason or other, failed to deposit the check with the insurance company. With the result, the policy lapsed, because when we don't pay the premium, the policy gets lapsed. Then that means we cannot claim any liability from the insurance company if the policy is lapsed. Then during the meantime, the car met with an accident, and in which 5 passengers have died and the car got badly damaged. This was the situation. Car purchased, when the purchaser paid the insurance premium to the bank. The bank failed to deposit with the insurance company. The policy is lost. Car met with an accident. 5 people died. Car is damaged. Now the consumer filed a case before the consumer court. Then the district for national company, they all said, they held that. They said the relief cannot be given to the person concerned because he did not pay the insurance policy amount to the company. They were making the consumer responsible and liable for not making the insurance policy premium amount. But however, the matter went to the Supreme Court, but the Supreme Court held otherwise. The bank was when the check is handed to the bank for depositing the insurance premium, it is the duty and responsibility of the bank to say deposit with the insurance company. Since there was a failure on the part of the bank is liable to pay all the damages and compensation. So therefore, that is not the important contribution made to the Supreme Court as for this case concerned. Failure of the bank to deliver relevant premium check to the insurance company amount to the negligence and deficient banking services concerned. Now we will take another important services, transport services. Transport includes road transport, rail transport, air transport, or others also. Now, in all these cases, the deficiency cases large number of deficiency cases have come before the court of law. Even we come across daily the school buses, if to poor or improper maintenance, the child have fallen from the bus, then they died also, came before the newspaper and all also. So this is clear case of deficiency in service on the part of the person who was given the responsible authority to carry the children from one place to another place concerned. Coming back to let us take the very specific case. It's about the case about the Chairman Tiruvallur Transport Corporation versus Consumer Protection Council Tamil Nadu case about. No, in this case, a person traveled in a bus, but the bus met with an accident and the traveler sustained serious injury. Then because then he got admitted to the hospital, he paid a huge lump to the hospital. Thereafter, became normal. He filed a case before the Consumer National Commission, which awarded compensation of rupees 5.1 lakh each, with interest at the rate of 18% and rupees 10,000 towards cost and all. So because there are several people died, the matter jointly went before the National Commission. National Commission came to the conclusion that yes, there was a deficient service on the part of the transport company. Therefore, they awarded this compensation of 5 lakhs rupees for each person is concerned. Now, this is the National Commission. However, the Supreme Court reversed the decision for a different reason. Supreme Court reversed the decision and held that this accident case squarely falls under the Motor Vehicles Act, and the Motor Vehicle Claims Tribunal has the jurisdiction to entertain such cases. Therefore, the injury sustained had nothing to do with the service provided, but fatal injury was the direct result of the accident concerned. So, whenever accident is involved, the Motor Vehicle Act is there, then the Motor Vehicle Claims Tribunal should see to this matter, not the Consumer Court. However, all other things I said, those things are covered under this. Now, air transport is air travel. Antonio Jago Fernandez versus Flight in Charge Jet Airways case. This is about a 2004 case. Just I am reading the rulings. Where a consumer with a confirmed air ticket is allowed to check in and issued a boarding pass and yet denied entry at the aircraft, it can be said that there is a clear case of deficiency in service. Therefore, it ordered a full refund of the ticket fare along with the taxi charges and interest and additional compensation for the mental suffering and agony. See, in the air service, most very often, once you enter the airport premises within the scheduled time of 30 minutes or 40 minutes, then you are entered to get a berth in the flight is concerned. Now, in this case, they have checked in within time, got a boarding pass also. Then even after getting the boarding pass, the fellow was denied entry into the aircraft. At the time of entering the flight, boarding the flight is concerned. This is the clear cut case of deficiency in service. So accordingly, compensation was awarded. This is about the air travel is concerned. And railway also. Railway, there are different type of cases, large number of cases. Again, we have the railway tribunal separately, but railway tribunal cases will be the matters covered in the Railway Tribunal Act alone will go before the railway tribunal. Other than those cases, that will come before the Consumer Court as well. Very often we come across, those who travel by train, they will come to understand. We go with the confirmed ticket again. You cannot board a train without having a confirmed ticket. A person, procured the confirmed ticket, seat was confirmed, berth was confirmed. When he actually boarded the train, then somebody else was allotted that seat in the coach is concerned. He showed that to the TTR, I am having the confirmed ticket. That fellow was having the confirmed ticket. With this fellow also travel without a seat and berth and all. After destiny, he filed a case before the Consumer Court alleging that there was a deficiency in service on the part of the railway company is concerned. The court heard the matter and came to the conclusion that once the confirmed ticket issued by the railway authorities, then failure to provide the berth and seat, it definitely amounted to the deficiency in service and all. So therefore, this is about railways concern. Now mutual fund, let me take one other case also. Mutual fund, Morgan Stanley Mutual Fund versus Ratkit Dam. This is the case. The mutual funds are also covered in the Consumer Protection Act. In this case, the Morgan Stanley Mutual Fund came with the public issue with the extensive advertisements. One of the allegations made was the mutual fund had not complied with the regulations of the SEBI. Then the issue raised was whether a prospective investor, that is the person who wanted to subscribe to the mutual fund, can be a consumer. The Supreme Court held that investor, not a consumer. Shares are not goods at the stage of application for the allotment. So complaint is a prospective investor of the future goods, hence not a consumer. So the Supreme Court said that investor or a prospective investor is not a consumer because he is not at the stage of making the application. There is no, neither he purchased the goods nor he purchased the share. That's it. And one more last case I would like to discuss about, water sports. Again, it's a case of Odra Municipal Corporation case where a boat under the supervision of the Odra Municipal Corporation, that is due to the company took 35 passengers against the capacity of 22 passengers. With the result, the boat collapsed and 20 people died. The main reason was, as per the requirement, the boat carried the people without lifeguards. So that is the biggest flaw committed by this boat in charge is concerned. But the boat was under the overall supervision of Vadodara Municipal Corporation is concerned. Now the one was again the issue what is the issue is whether Vadodara Municipal Corporation is a service provider or not, because it's a statutory authority. Earlier also we saw a case of this nature only. Now and then then the consumers are whether it's not a service provider before the victim or consumers or contractor was not a service provider. This was the matter. The Supreme Court held that deficiency in service to the established insurance company made liable to pay 20 lakhs per accident cases. Actually, the Supreme Court came to the conclusion that the victims are the consumers and the company is the service provider coming under the consumer concern. Just last only one case, please. Legal provision is covered under the Consumer Protection Act if the lawyer failed to appear on behalf of the client, or if the lawyer failed to hand over the papers to the customer on the plea that the payment is not made and all. These two things amounts to deficiency in service. In a nutshell, legal profession is covered in the Consumer Protection Act. Therefore, a legal advocate failed to appear before the court of law or refusal to hand over the case papers to the client on the plea that he has not paid the fees, these two categories are definitely come under the deficiency in service under the Consumer Protection Act is concerned. Therefore, legal profession is covered under the Consumer Protection Act is concerned. Thank you very much for listening this discussion, please.